arrest of Richard M. Allen is sure a major step in leading to the conclusion of this long-term and complex investigation.
Shame on you! Shame on you, Richard! You're going to prison for the rest of your life!
The Delphi transcripts have been released, but now the question is, will the judge be removed from the case? And we're getting an update on the OnlyFans Model Murder Case as we go one-on-one with one of Courtney Clenney's defense attorneys. Plus, Alex Murdaugh admits guilt in his financial crimes case, saying that he accepts prison time for something that he did do. So will this be a defense tactic if he's given a new murder trial? It's all coming up next for you right here on Opening Statements. A very good Wednesday morning to you and welcome to Opening Statements. I'm your host, Julie Grant. It's great to see you today. This is a busy week in the world of true crime and trial. It's also a busy holiday week and we're so glad you are here with us. If this is your first time watching the show, thank you for that. We like to think it's kind of like the opening statements at trial, the actual opening statements that the attorneys deliver that get the jury all primed and ready to hear the case evidence. Well, that's what we do here for you. We get you all primed for Court TV Live to begin at 9 a.m. So we preview the big trials we're covering. We do deep dives with tremendous expert guests to get you ready for those big stories we're following as well that head to trial eventually. Right now, it's time for you to grab a cup of coffee. It's time for my opening statement. My friends, you are a blessing that I am grateful for every single day, and certainly on this upcoming Thanksgiving holiday. I hope that you and your loved ones have a wonderful time together. And really just being able to be together is a blessing in and of itself, right? And as we know, not every family will be as fortunate this year. There are so many families whose cases we follow here on Court TV that have experienced the tragic loss of one of their loved ones. So let's keep those families in our hearts this Thanksgiving, wishing them comfort and peace as they celebrate the holiday without that person or the people who meant the most to them. You know, no matter how full of food their table is, their hearts will never be full again after the loss that they've suffered. And when we think of the holiday season, it's really a great time to give back. So let's think about victims' resource centers as well. They are all over the country, always in need of donations for their programs. And for example, think about a domestic violence case, for instance. A person may have to leave their abuser with nothing but the clothes on their back because they may have to leave their home immediately and leave all of their possessions behind for their safety. Think about that. And then restart their life. So if you have things you may want to donate this holiday season, like clothing, bedding, toiletries, kitchen items, pet items, those things might be just as helpful to one of those victims' resource centers as a monetary donation. So just something I wanted to give you to think about as we enter the holiday season, because as you know, my friends, there are so many crime victims who need us to hold them in our hearts and help them if we can. That's my opening statement for this Wednesday morning. Let me know if you like it. Right now, it's time for your big updates. We have got some more drama to tell you about out of the state of South Carolina, where Jeffrey Colton Hill, the son of Clerk of Court Becky Hill, has been arrested. Officials say a felony warrant was issued for his arrest on Tuesday. Hill is currently listed as the county's technology director. He was taken into custody, booked in the Colleton County Detention Center. The charges have yet to be posted online, but according to Fitz News, Hill's arrest stems from a single count that's tied to a broad wiretapping statute. Now, this comes on the heels of his mother's own legal battles, as Becky Hill, as we've been telling you, has been accused by the Murdaugh defense team of jury tampering.
When we considered what factors and what we should and should not do and considered whether he should take the stand, we never considered the likelihood, as reported to us by the jurors, that the clerk of court would go in to the sanctity of the jury room before he testified and tell the jurors, don't be fooled by his testimony, watch out for his body language. And that is what the sworn testimony that we have filed in court today says. And if that is true, which we have every reason to believe that it is, and no reason to believe that it's not, there's no choice but the courts to grant a new trial.
Let's bring in our guest to talk about this. I have with me criminal defense and civil rights attorney Kesia Early and criminal defense attorney and former district attorney Matthew Mangino. Good morning to you both. Okay, so we don't know a lot at this point, but of course I think everybody's mind is just kind of spinning, wondering if this could be connected to those jury tampering allegations from the defense team. So I want to get your initial thoughts on this, please. Kesia, ladies first.
Good morning, Julie. Thanks for having me. All I have to say is what is going on in Colleton County? I mean, this was a small town that's basically the center stage for everyone is wondering, from the clerk of court to now her son, is this connected? And I can tell you right now, if it is, I do believe he'll get a new trial. However, I do not believe that, based on the evidence that we saw in the first trial, that there will be a different outcome. But ultimately, we want to make sure that a trial is fair. I mean, we go through this long 6-week process, picking a jury, cross-examination, direct examination, just to do it all over again. So yes, I do believe that everyone should adhere to the rules of the court and make sure there's a fair trial and due process.
That's right, Kesia. Matthew Mangino, your initial thoughts on this, please.
Well, it's, the twists and turns, Julie, of this Murdaugh case are just unbelievable. I mean, it's one of those situations where, truth is stranger than fiction. I mean, it just keeps getting better and better. And ultimately, prosecutors don't want to try a case twice. I mean, I know as a prosecutor, I did everything I could to make sure that things were fair and that the evidence was presented that should be, and evidence that shouldn't be presented wasn't, because I didn't want to try a case twice. But you can't control necessarily the clerk of courts or the clerk of court's son. So I'm sure that there's prosecutors in South Carolina who are very disappointed by these developments and how they've evolved at this point.
Yeah, you're absolutely right, Matthew. Absolutely. They have to be sick about this, because they want everything done the right way, and they've done everything on the up and up, and so certainly they don't want a conviction coming in the wrong way. They want it to come in truthfully, justly. I want to play a clip from when Becky Hill came on this show, and this was prior to these allegations. It was after she made the announcement about writing that book. As clerk of court, she came on with her co-author, very pleasant lady, as you'll see in the interview, and I can't stress enough how she has not been accused of any crime. These are allegations coming strictly from the Murdaugh defense team, and what's going on with her son, that's separate and apart. As far as we know this morning, that could change. So let's take a listen back to some of what she told us on opening statements.
Well, he was just like any other defendant in some ways. And he would come in every morning from the jail van. They would bring him in. Of course, there was a lot of people trying to get pictures of him just getting out of the van and into the gated area, which brings him to an elevator in our courthouse and down to his holding cell where he was kept when he was not in the courtroom. So we have cameras on every area of the courthouse, inside and outside. So we were able to keep an eye on him. Sometimes he was reading. Sometimes he was laying down. Sometimes he was pacing the floor. But when he was in the courtroom, at first he was chewing gum and eating candy and trying to talk and nod and speak to people that he hadn't seen in a while.
So talking, of course, about Alex Murdaugh, and she shared that their families have a long history together, small town, grandparents knowing each other, and she writes this book because of the unique position she's in. Now she's under the microscope. Kesia, when we hear this broad allegation, and again, Fitz News doing the reporting on this one, saying that the tie with Becky Hill's son to this criminal case is some type of wiretap violation. Can you kind of give us maybe a broad idea of what that could encompass? I know you're in Florida, for instance. States are different, but what this could be.
Well, I was thinking the same thing, reviewing the reports. I was absolutely surprised. But then when I thought about his position in the courthouse, he's the director of information technology. So could it stem from his job, or is it something that he did separate? I mean, it's really broad, as you stated, but I do believe that the allegations are serious enough where they were able to have sufficient probable cause and issue this arrest warrant. But I'm wrestling my brain trying to figure out the connection with the jury, with the court, with Alex Murdaugh. Like, how did he obtain this information? So I'm at a loss in this early stage.
Right. No, it's tough. I mean, who knows? We don't have a lot to go on at this point. And a wiretap violation, they can be, so many different things. I know, for instance, in Pennsylvania, Matthew Mangino knows this, where we're both licensed to practice. You need both parties consenting to the recording of a phone call, for instance. And if somebody does that without the permission of the other party, they could be charged with a felony under the Wiretap Act. A lot of people don't know that, especially in the day and age where everybody's recording TikToks and Facebook Lives and all that stuff. So who knows? But as more information is released on this, we're going to bring it to you here. Casey, early Matthew Mangino, I'm so glad you both are on the show. We have some new developments we want to go to now in another big case we're following at Court TV. This one we told you about the other day on opening statements. Those teenagers charged in the murder of their classmate. Well, the 4 that are being charged as adults made their first appearance in court on Tuesday. These are them: Trayvon Randolph, Damian Hernandez, Dontrell Beaver, and Gianni Robinson, all facing murder charges for their alleged roles in the fatal beating that killed 17-year-old Jonathan Lewis. This is a picture of the victim here. That video of the attack, speaking of video, somebody filmed it, did not rescue him, but filmed it. The video went viral. 10 people are seen in that video punching and kicking him. It was absolutely brutal. We have that video. We're going to play a short clip of it now. Just want to warn you, it is quite disturbing. Now, so far, 8 teens have been arrested for this. The 4 we mentioned earlier tried as adults. Here's Scripps News Las Vegas with a closer look at this case.
4 of the teen murder suspects accused of beating their Rancho High School classmate Jonathan Lewis to death did not enter a plea in court Tuesday morning. Trayvon Randolph was represented by a special public defender, and Gianni Robinson, Damian Hernandez, and Dontrell Beaver were all represented by court-appointed attorneys. According to an arrest report obtained by Channel 13, when officers arrived at the crime scene, they found drops of blood located on some boards by a fence. The report also reveals a detective provided officers with a video of the fight, which had been posted on Instagram. Police say the video shows 10 people punch, kick, and stomp someone on the ground, and then the group turns their aggression on someone trying to break up the attack. Clark County School District administrators were able to identify for police several of the suspects, leading to the arrests. Also, according to the report, a detective believes the fight possibly involved gang members. Police also say multiple people recorded video of the crime. Family members of the teen murder suspects packed the courtroom Tuesday. Channel 13. Anything you guys could say to us? The father of Robinson had this to say about the court proceedings.
Well, at least they're putting them back in juvie and not holding them down here with all the other people, all the other real criminals.
Anything you want to say to the family of Jonathan Lewis?
I'm sorry that happened, but you take a knife to a fight, that's what happens.
The teens are back in court on December 14th. At the Clark County Juvenile Detention Center, I'm Jae-Won Jung.
Oh boy, these juveniles being charged as adults. Let me bring back in Matthew Mangino and Casey early to get their thoughts on this one. Just sickening what happened here. Matthew, when you think about the weighty decision to charge a juvenile as an adult and pursue that way as a prosecutor, would you talk to us about some of the things that go into that decision when you make it in the district attorney's office, please?
Well, Julie, those are always difficult decisions, and in some jurisdictions, the legislature has taken that responsibility away from prosecutors and said, listen, if you used a weapon in a crime, and you're over the age of 16, you're automatically charged as an adult. Now, that doesn't seem to be the case in Nevada. So in Nevada, you have to be certified to adult court if you're under the age of 16. If you're over the age of 16, you can be tried in the adult court without a certification hearing. And that's why we see, 4 people 4 young people being indicted, and then there's going to be hearings on the others because there's as many as 10 people involved in this. And it's a difficult decision. You look historically at what kind of person this juvenile was, other history and that sort of thing. So it's a difficult decision for prosecutors to make.
Certainly it is, Matthew. Thank you for that. I have a clip from one of the defense attorneys. His name is Robert Draskevich. He's representing one of the 17-year-olds who's facing a second-degree murder charge. And in this clip, he's sharing that there's more to the story that's going to come out throughout the trial. Let's watch.
The case will proceed in adult criminal court. We'll be receiving and reviewing all of the discovery. I've been told that the videos that have been released are incomplete, and I'll be going through all the videos with my investigator to see what really happened.
All right. So these attorneys have a tough job. Casey, tell me, what do you think is going to be the biggest hurdle for these defense attorneys representing these kids? I mean, they are kids, they're minors. What do you see as the biggest challenges coming up for them, please?
Yeah, the biggest challenge is that the victim in this case was outnumbered. It was clear that they weren't fighting in self-defense. They had others, they jumped him, they obviously overpowered him. So they have to overcome, if they claim self-defense, whether or not there was a true threat, there was a true fear. And it's just unfortunate because, you know, these are teenagers and they just lack complete disregard for human life in this case.
Appreciate it so much. Casey Early, Matthew Mangino, stand by if you would, please. Here's what's coming up next on Opening Statements.
Baldwin, can you provide any comment?
Journalism. It's time for you guys to start being journalists.
All right, the transcripts are out of that in-chambers meeting with the judge and Richard Allen's first attorneys. Will they establish that they were forced off the case? And will they serve as a reason for the judge to be removed? We're talking about it next. Also, knife throwing will be playing a key part in the murder trial of OnlyFans model Courtney Clenney. This morning, we're learning more as one of Courtney Clenney's attorneys is joining us live on the show.
A former police officer charged in the chokehold death of his friend.
His conduct was not only criminally reckless, but showed utter disregard for life.
Mr. Mattioli acted reasonably, and he acted appropriately.
I knew that as soon as he got back up, there was going to be more punches thrown.
You'll see this dramatic trial unfold right here on Court TV.
I know what I did. I know I wasn't choking him.
The deadly cop chokehold trial. Trial coverage today on Court TV.
We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rosie will be submitting a written motion to withdraw, I'm assuming within the next couple of days.
Now to what is trending in true crime. That transcript of that private meeting with the judge, the prosecutors, and Richard Allen's first defense attorneys in the Delphi murder case has now been made public. The October 19th meeting happened prior to a scheduled court hearing that day. Remember, everybody was present in the courtroom, and there was a delay, and then suddenly the attorneys are no longer on the case. Well, the parties met with the judge in her chambers to talk about the leak of that confidential crime scene photos, that happened through attorney Andrew Baldwin's office. Now, Baldwin even brought his own lawyer to court that day. Former counsel Bradley Rosie and Andrew Baldwin said that they felt ambushed because they didn't know that the judge planned to hear arguments at that hearing about why they should be removed from the case. And the prosecutor came prepared with witnesses and exhibits to present to the court, while Rosie and Baldwin were unprepared and claimed that they were kind of blindsided by that. So does the release of these transcripts help or hurt the defense claims? I'm looking at a piece of it now, and at one point, the judge is saying to them, that she is unsatisfied with the representation of Richard Allen, that she looks at the totality of the circumstances, and based on everything that's occurred, she sees gross negligence and she sees incompetence with them. And her words, she said, "I'm gravely concerned that Richard Allen will not be receiving competent representation with the two of you." And Mr. Rosie questions the court and said, basically what you're saying is you guys either quit on your own accord or you make me fire you. And she said, no, that's not what I'm saying, but this is what I plan to say on the record when we convene at 2 o'clock. And so the attorneys had said before the transcript was released that they were being given kind of a Hobson's choice, that it was either you bow out gracefully or you're going to have to bow out gracefully because I'm going to publicly shame you and share my thoughts about you being grossly negligent and incompetent. Richard Allen was not part of that in-chambers meeting, and he and his family were very upset about this and want those original defense attorneys back on the case. And those attorneys want the judge removed. So let's talk about it all. I want to bring in my guest, criminal defense and civil rights attorney Kesia Early, criminal defense attorney and former district attorney Matthew Mangino, and criminal defense attorney Bradford Cohen. Great to have you all to talk about all this. Okay, so in terms of whether this dialogue substantiates what these defense attorneys came out publicly and said before the transcripts were public, what do you all think? Does it help kind of solidify their claims that they had no choice and should have been given a choice? Kesia, I'll begin with you, please.
I think they did have a choice. If they believed that they were prepared as attorneys to represent the defendant in this case, I would have stayed on the case and let the judge, give her argument from the bench and make her ruling and sign her order. But I understand the judge's position because this sets it up for appeal. Ineffective assistance of counsel, she was concerned that there was gross negligence. But you can't really tell what a defense attorney or how a defense attorney is preparing their case for trial. So, I mean, she's treading on thin ice because you don't know whether or not they were truly incompetent or did not have the ability to represent the defendant. I mean, what specific issues other than not coming to court with particular exhibits brought this to your concern?
Appreciate that, Kesia. Let's dovetail off what you just said. Thank you for that. Bradford Cohen, tell me, does it trouble you as a practicing criminal defense attorney that the judge made this finding? She said she's finding gross negligence by looking at the totality of the circumstances, but we know there was no hearing on the leak. There was no opportunity for the defense to kind of defend themselves and how this happened through the office of Andrew Baldwin. Does that trouble you as a potentially a due process issue?
It's very unusual. I've never seen anything like what exactly happened here in terms of her calling them into the back of the chambers and discussing this with them, saying that they're incompetent. She could have addressed this in open court, and in addressing it in open court, she could have asked the defendant if he felt that he was being represented effectively, if he felt that he was being represented well, and that he was satisfied with that representation. So there's a lot of things that we could have done here in terms of getting to where she needed to go. And I do think they had a choice. I do think they could have stayed on the case and had her rule from the bench and have them rule from the bench in terms of them getting them off of the case. But again, that's their choice that they made in terms of them withdrawing instead of her saying that she's going to take them off. She essentially said she was going to take them off if they didn't do it. So that's what was so unusual about this case. I would have definitely not withdrawn. I would have let her made her motion and let her made the ruling from the bench, which I think would have been incorrect. Mm-hmm. And I also think that there's probably a very good motion to have her disqualified from the case.
Mm-hmm. Yeah, we're definitely going to talk about her. We'll revisit that in a second. Bradford, thank you for that. In this transcript, Brad Rosie many times, and I think his words at one point were, this is screaming due process, saying this is a problem that we're not being afforded that, and this is just kind of a decision where either you quit or we all go out there on the record and you shame us, which isn't fair. Matthew Mangino, a very specific question for you. Something that troubled me, and I'm sure I'm not the only one, was that it seems in reading this transcript that these prosecutors came ready to go. They came with exhibits and arguments, and they were just prepared to go on the attack. And these defense attorneys were saying, whoa, we're blindsided, essentially. Like, what is this? We're having a chambers meeting right before we all go out there for the hearing, and you're ready to have a hearing and hear on the leak and all of that. Does that signal anything fishy to you, Matthew, that these prosecutors might have been aware that something was going to go down?
Well, you're right, Julie, and you said fishy, because what I was going to say is that this doesn't pass the smell test, okay? This is just, the prosecution is aware of what's going to happen. The defense isn't. The defendant isn't present. Nothing here, in my mind, seems to say that there was due process either for the defendant or a reasonable opportunity for counsel to defend themselves based on what the judge was concerned about.
Appreciate it, Matthew. Right, it does not seem to pass the smell test. It just stinks. So much of what's going on in Delphi just really stinks to high heaven. It does. And who knows if these attorneys are going to be back or if the judge is going to be removed. Bradford, you touched on this a little bit, and let's go there now. So on the heels of all the drama with the judge sadly had a health scare. The Honorable Fran Gall is the judge we're talking about here, presiding over this case. She's currently working from home after court officials say she was treated for an urgent medical condition earlier this month. So now her Honor's caseload is being handled by other judges in that jurisdiction, except for the Delphi case. So considering what we know now about that October 19th meeting, should those petitioning to have her removed get their wish? We know that this is something that was brought up in what's called a friend of the court brief by some attorneys who wrote a brief essentially on the behalf of Richard Allen, saying that she ought to be removed for not affording due process to these attorneys, for threatening to publicly shame them and giving them a Hobson's choice, so to speak. Let's bring back in our legal eagles, Matthew Mangino, Bradford Cohen, and Casey Early. I'm going to go reverse order here. Matthew, let me begin with you here in terms of whether the judge should be removed. These relators, as they call them in Indiana, filed this friend of the court brief, and they took it all the way up to the Indiana Supreme Court. They want them to be the one to make the call. What do you think we may see happen here, and why, please, Matthew?
I think she should be removed from the case. I think her decision to kind of act unilaterally, saying, hey, remove yourself from the case, withdraw, or I'm going to publicly embarrass you, is coercion. Doing that without the input of the defendant is a huge mistake. And letting the prosecution know ahead of time, hey, I want these guys removed, and I want you to present a case why they should be removed, I think is really beyond the scope of what any judge should do in a case.
And you've got a lot of experience in the criminal court system, both as a prosecutor and criminal defense attorney. Bradford Cohen, let me go to you. Do you concur with your colleague here?
100%. I mean, this is an easy call. I think she should remove herself, to be quite honest with you, because of what's going on. And also, in addition to her health issues, I don't think that this is even a close call. I think that she should be removed and a new judge should be appointed.
Appreciate it. We have to leave it there for now. For time's sake, Casey is going to stay with us as we continue with the show. I have to say goodbye and a big thank you to Matthew Mangino and Bradford Cohen for joining us on this holiday eve today, for making time. Thank you both so much, and happy Thanksgiving to you and your families. When we come back, friends, we're going to dive into the OnlyFans Model Murder Case. One of Courtney Clenney's attorneys is joining us live on the program. Did she stab her boyfriend in a fit of rage, or did she throw that knife in self-defense? We're talking about it. And we're looking ahead to Alex Murdaugh's sentencing in his financial crimes case. How might his guilty plea play into his potential murder retrial?
A former police officer charged in the chokehold death of his friend.
His conduct was not only criminally reckless, but showed utter disregard for life.
Mr. Mattioli acted reasonably and he acted appropriately.
I knew that as soon as he got back up, there was going to be more punches thrown.
You'll see this dramatic trial unfold right here on Court TV.
I know what I did. I know I wasn't choking him.
The deadly cop chokehold trial. Trial coverage today on Court TV.
Ma'am, listen to me. You need to stop screaming on the line and give me the address. You're gonna die. I can't feel my arm. I can't feel my arm. What, ma'am? So my boyfriend is dying of a stab. Ma'am.
This morning, we're shining a spotlight on the homicide case being brought against former OnlyFans model Courtney Clenney. She's being accused of stabbing her boyfriend to death during a fight back in April of last year. Prosecutors are calling it a murder. They painted her as the aggressor and the abuser. But Courtney Clenney has a fierce defense team, and they are fighting back hard, saying that she was actually the victim and the stabbing was done in self-defense. Let's listen together as Clenney explains her version of events during her interview with police.
So I grabbed my knife and I said, don't come anywhere closer to me. I had absolutely no intention of using it. I'm on the phone with my mom and he's coming at me like he's gonna grab either the phone or like the knife or something. And so I was just like, I was like, don't come any closer. It's coming at me, and I drew it. And I meant for it to go.
How far away was he?
Well, I was by my fridge, and he was like by the edge of one of the chairs of the sofa.
Okay.
Like
comparing to what
10 feet. I'm trying to think in my head.
All right, I'm so pleased to welcome Courtney Clenney's defense attorney, Sabrina Puglisi. Sabrina, good morning to you. Thank you for coming back on the show. You and your wonderful colleague, Frank Prieto, have been really great in being transparent in your defense work and what's going on with this case that has a lot of evidence that you've been sorting through. So could we start with kind of the latest? We know that you all had a court date set, and I understand there were some pretty big new developments.
Yeah, so thanks again for having me. And so the other day we had a hearing. It was supposed to be on a motion to suppress that we had filed the defense. And so what we did was we asked for it to be tabled, to take it off the calendar, because we agreed that the motion really needs to have some more specificity as to which videos specifically we're referring to. So what we are going to be doing is preparing an amended or supplement motion that we'll go ahead and file. The judge has given us time to do that, and we'll just put it back on calendar when we're ready to do that.
Okay. And so we know there is a lot of video evidence, and I guess where my mind went when you were saying that, Sabrina, was some of those videos that we know Christian Abamseli, who's the decedent, of course, in this case, had recorded surreptitiously. Are those the ones that might be at issue?
Exactly. And what we need to do is, there's a lot of videos on his phone, and we really need to just comb through and, look through every single one to make sure that we have all of them, because the judge really needs to know exactly which ones we are seeking to suppress.
Sure. So fair enough. Okay, so that's off the table just for now, but you'll revisit suppression sometime down the road. Something I want to talk about with you, please, Sabrina, that you and Frank touched on the last time you both came on opening statements, and you said you were going to have your own knife-throwing expert, and we were all left with like, oh my gosh, we want to hear more. So let's start with a clip. This is from the state's medical examiner in a prior hearing talking about the knife that ultimately killed Christian Abamseli possibly being thrown.
Based on the information you received that the defendant was alleged to have thrown this knife, do your observations support that?
I'm not an expert in knife throwing. If the person who supposedly did this is an expert knife thrower, and the knife is the type of knife that you can throw, I guess that could have happened.
And so, Sabrina, you and Frank, walk us through the process. You both have sought out a knife-throwing expert, and I understand you have them ready to go for trial.
That's right, Julie. As you know, the state's case has always been that it was not possible to throw the knife, and their expert says that. But what he does say is that he's not a knife throwing expert. And so what we did was we actually went and sought out a knife throwing expert, and not just any knife throwing expert. We sought somebody who's very well renowned, Bobby Brenton. In fact, he's even taught celebrities for movies how to throw knives. He has demonstrated he's used those exact knives that was in this case. And he has been able to throw the knife and hit the target. In fact, I'll tell you that even I've been able to do it. So it is very possible. He's going to testify to that at the trial, that from the distance that she says she was, that knife can absolutely be thrown, and it is consistent with Courtney's statement that she was afraid, he was coming at her, and she threw the knife. Additionally, we have one other expert that we just noticed, and that is our own defense medical examiner. And he, unlike their medical examiner, does have experience in knife throwing as well. And he absolutely will testify that it is consistent, the wound is consistent with a knife being thrown.
Wow. Sabrina, as you know, this could be a real game changer at trial, these expert witnesses. You said Bobby Brennan, is that right? Did I hear the name right? Is the knife throwing expert?
It's Branton.
Oh, Branton, okay. And how about the forensic pathologist? Do you mind sharing with us who that is?
You know what, it's listed, but I'd rather, because I haven't spoken to him, I'd rather not disclose his name.
Sure.
But he is also very well-known medical examiner, and so we feel very confident with these two experts that it will be consistent with not just our defense, but with Courtney's own statements.
Oh, you have us wondering, somebody who's been around a long time?
Yes.
Perhaps. Oh boy. You know, and I'm going to say, you don't have to say anything, but I keep thinking about Dr. Michael Bodden. We saw him testify in a trial recently. Dr. Cyril Wecht still does autopsy consulting. Curious if it's either of them. We'll respect things until you have everything solidified. But that's interesting to note that you did have. Was it, can you tell us, did they review the first autopsy report, Sabrina? Is that how they came to their findings?
Absolutely. He reviewed that, and then he also was present for when we did a demonstration of the knife throwing, which I will tell you, we are going to be seeking to introduce a video of that demonstration so that a jury will be able to see how Mr. Branton is able to throw that knife and get it to stick into a target.
Wow, this is really quite fascinating. That has been her story from the beginning. It's been consistent. We know the toxicity is certainly there. Her family acknowledging that from the outset. Certainly, I'm sure you and Frank will acknowledge that throughout your case presentation. I have a clip from Courtney Clenney's dad talking about it in a previous hearing. I want to play that now.
It was very toxic. And I knew from the beginning that he was not treating her correctly. I saw proof with my own eyes. I heard calls between them, calls to my wife. I heard many things that a father who loves his daughter very deeply should never have to put up with.
Sabrina, I'm curious, and I know it's still early. We're not on the eve of trial exactly. You have some time to go, but is it your plan to call some of Courtney's family members as witnesses?
I don't know that I would say family members, because we really want to make sure that we have people who have witnessed that toxicity, but not just the toxicity in that relationship, but the violence on the part of Abumseli, to show that this is not Courtney who's the aggressor. And so we will be presenting additional witnesses that have witnessed that.
And we're looking at the elevator video. That's one that you want in again, right? Sabrina, we talked about this on another date. You were saying you all think this helps your case. Is this not one you're seeking to suppress?
Absolutely. No, we're not seeking to suppress this.
Okay.
We are good with this coming in because I think if you look at his face, how he taunts her during this, how he holds her away so he can get upstairs even though she doesn't want that. You know, look at his face right there. I think it's very key into the emotional and physical abuse that she suffered at his hands. But this will just be one piece of the whole picture that we'll be putting together and showing.
Well, I've said this before, I'll say it again. I can't wait to see you and Frank in action. These facts are tough. This is a very sad case. Courtney Clenney really has the best defense possible with you both. Sabrina Puglisi, thank you so much for your time. Please give Frank our very best. Tell him we're thinking about him. And happy Thanksgiving to you.
I
all
will.
and
Happy
family.
Thanksgiving to you.
Thanks
Thank you,
so
Julie.
much. When we come back, friends, we're gearing up for sentencing day for Alex Murdaugh. It's next week, and he says he was happy to plead to his financial crimes. But could this be motivation for a strategy coming up if he gets that new murder trial that he wants? We'll talk about it next.
Alex Murdaugh, convicted double murderer, just accepted a plea deal from prosecutors.
How do you plead?
I plead guilty, Your Honor. He stole the money from Tony Satterfield.
Over $1 million of his own client's settlements. Why did you agree to that?
Because I trusted him.
This unbelievable fall from grace.
I was selfish, and I just took the money.
The Murdaugh Stolen Million sentencing. Live coverage Tuesday morning, 8, 7 Central on Court TV.
Now to what's tipping the scales as Alex Murdaugh faces sentencing on Tuesday for his financial crimes. The convicted killer said he happily pleaded guilty, and his attorneys say he has no issue serving time for a crime that he committed.
He's prepared to serve a long time. As he said to me as we were going into the courtroom, you know, he feels very comfortable doing prison time for crimes that he did, and he knew that he was going to prison. He does not feel comfortable doing prison time for the murders of his wife and son, for which he did not do. And we still are singularly focused on exonerating him.
See, here's what I'm wondering this morning, friends. I'm wondering if this is part of a bigger strategy to look good if he gets that second murder trial. Because, you know, the financial crimes are a big part of the first trial if Murdaugh gets his wish. Is this all part of what the defense is trying to do? Say, look at him. He's like a choir boy. He's being so good, pleading guilty to these crimes because he did it, but he didn't do the murder, so that's why he's not pleading. Let me bring in Casey early and welcome in Tommy Pope. Tommy's joining us. He's going to be with us the next hour after we say goodbye to Casey. So, okay, what do we think about this? Could this be a bigger defense strategy? Casey, I'll start with you, please.
I don't think so, because it doesn't help. I mean, this is a crime of dishonesty. And before, in the murder trial, these were just allegations. Now he's a certified convicted felon in custody. So he already admitted to it in the first trial. He's going to obviously admit to it in the second trial. I think the only way that he has a chance at an acquittal is if they get Paul's phone suppressed. And there's no way that that's happening, because that's the most damaging evidence that was utilized against him, and all the lies, of course, that he told afterwards. So no, he's still going to be found guilty. Overwhelming circumstantial evidence.
Yes, you're right. Even if he gets that second trial, it's not going to go well. Tommy Pope, what do you think? Do you think this could be part of a defense strategy, or maybe Murdaugh's master plan?
I think there's a couple different pieces. One, if he has the convictions, the cross-examination will be a little cleaner. You remember how many hours we went through of locking down those crimes, so that would be locked down. So it actually would tighten it up, because ultimately in the trial he admitted it. So it says, was just said, it'll be tighter in that regard. I was thinking, one, they're given a sentence certain plea that if the judge doesn't accept it, there's he can't go above or beyond, below it. He's just got to accept it or not. It might be locking in a ceiling, kind of like you do on negotiations. So later on, if he had to plead to the murders, and I'm not saying he would, maybe they try to tie that cap in there. So, you know, maybe it's a strategy ultimately to lower the amount of time he ultimately has to do.
Oh, that's another really good point. Tommy, thank you for that. Tommy's going to stick around with us. We have to say goodbye and a big thank you to our friend Kezia Early. Kezia, happy Thanksgiving to you and your family. See you soon.